Thank you. Mr. President, distinguished members of the court, from the presentations you heard yesterday, there can be no doubt that the Tatmada's clearance operations in Minji, Chatpin, Mangnu, and 4 other villages that Mr. Njai discussed were carried out with extreme brutality. The UN fact-finding mission reported that a similar and strikingly similar modus operandi was employed in at least 54 other Rohingya villages, and it concluded that the extreme brutality with which these operations were carried out across northern Rakhine State was a compelling indicator of Myanmar's genocidal intent. In its words, genocidal intent was evident in the Tatmada's extreme brutality during its attacks on the Rohingya. The court is now well aware of the underlying facts, so let us turn to the jurisprudence. It is beyond dispute that the brutality of an attack on a protected group constitutes evidence of genocidal intent. The court itself recognized in Croatia versus Serbia that genocidal intent can be inferred from, quote, the scale and allegedly systematic nature of the attacks. The fact that those attacks are said to have caused casualties and damage far in excess of what was justified by military necessity. The specific targeting of members of the protected group and the nature, extent, and degree of the injuries caused to the protected population. The ICTY and the ICTR have also found genocidal intent based on the brutality of an attack, not only through the attack scale and those targeted by it, but also because of the extent and the degree of injury which the attack caused to its victims. Each of these hallmarks of brutality evidencing genocidal intent is present in this case. Myanmar's clearance operation is large-scale and systematic. It caused civilian casualties and destruction far beyond any military necessity. They targeted the most vulnerable members of the Rohingya group, and they were deliberate and extreme in their cruelty. I begin with the scale and systematic nature of the crimes against the Rohingya. The ICTR trial chamber in the Nadine Dabahazi case explained that an attack on several thousand members of an ethnic group is itself indicative of the requisite intent to destroy that group in whole or in part. Similarly, the trial chamber found in the Akeyesu case that an attack on a massive scale indicated that the massacres were aimed at exterminating the group. Our case fits the description here. As Mr. Lowenstein explained yesterday, in 2 waves of the clearance operation, Myanmar mounted a systematic and large-scale attack against the Rohingya. The UN fact-finding mission concluded that while the exact number of casualties may never be known, the clearance operations that started on the 25th of August 2017 alone have directly resulted in more than 10,000 deaths, an estimate it considered to be conservative. The United States Department of State's report found that the attacks were extreme, large-scale, and widespread. 1 in 5 witnesses interviewed had seen a mass casualty event of killings or injuries with more than 100 victims. The Holocaust Memorial Museum also found that, quote, the Myanmar's army attacks against the Rohingya population were both widespread and systematic. I now turn to the second aspect of Myanmar's brutality, which evidences genocidal intent: casualties and destruction far beyond any military necessity. In Bosnia versus Serbia, the court recalled the ICTY's findings that the executions in Srebrenica systematically targeted Bosnian Muslim men of military age regardless of whether they were civilians or soldiers, with no effort to distinguish between them. The ICJ treated this pattern of indiscriminate targeting as probative of the intent to destroy the Bosnian Muslims in Srebrenica, in whole or in part. This court accepted the same factor as an indicator that genocidal intent was present in the particular circumstances of Srebrenica. The Tatmadaw too systematically targeted civilians with no effort to distinguish between civilians and RSF fighters. You will recall this excerpt from the UN Fact-Finding Mission's 2018 report. There was not the least effort on their part, that is the Tatmadaw's part, to make any distinction between RSF fighters and civilians, or to specifically target a military objective or identify and repel an immediate threat. Everyone was a target, and no one was spared. Later today, Mr. Sulman will explain why Myanmar's clearance operations were not counter-terrorism operations. Myanmar consistently employed at least 4 methods of violence that reveal an intent to kill as many Rohingya civilians as possible. You already heard yesterday evidence of 3 of them: indiscriminate shootings, burnings to death, and targeted executions. There is ample evidence that these methods were repeated in multiple Rohingya villages, which will be included in the footnotes of the compte rendu. Mr. President, attacks on escape corridors is the 4th modus operandi consistently employed by the Tatmadaw. Even after forcing the Rohingya to the Bangladesh border, the Tatmadaw was not satisfied. They wanted the Rohingya dead. As the UN Fact-Finding Mission determined, Tatmadaw soldiers shot at groups of Rohingya who were en route. At times, these attacks occurred in villages that were already burned